Good morning, everybody. I'm Rick Daly from Daly Black. I think most of you know who we are. We're based out of Houston, and we've grown now to the point where we really work nationwide. We've got offices in Denver, in New Orleans, and in Florida as well. And I want to talk today about just recent issues that we've seen in the past year. As you know, the insurance companies do anything they can to save a buck, and I'll show you some of the things that I'm seeing and talk to you about how to deal with it. The cosmetic damage exclusion, we're starting to see this over and over and over. Raise your hand if you've been involved in a case where a claim got denied for a cosmetic damage reason. Okay, a lot of them. We're seeing that virtually every metal roof is getting denied on this basis, and the thing that's interesting is we're starting to see cases that are getting denied for cosmetic damage reasons when there's not a cosmetic damage exclusion. So I'm going to talk to you about how to deal with that and what you're looking for there. The second thing I'm going to talk about is the Texas Prompt Payment of Claims Act. What people don't understand is that the TPPCA requires insurance companies to pay penalty, interest, and attorney's fees when they don't comply with the deadlines in the Texas Insurance Code. And it's based on prime rate. And so if you've been paying attention to the federal prime rate, you've seen it's gone through the roof. And so there's a big advantage here for you all and for policyholders that you need to know about. The third is we're doing a lot of stuff in Louisiana now, and the laws are different there. And with regard to public adjusting, and I want to talk to you about some of the pitfalls there and what you need to do from a legal standpoint. First thing is, don't forget that if there's not a cosmetic damage exclusion, then cosmetic damage is covered, okay? We just got a really nice opinion out of Colorado federal court where the experts on the other side kept saying, well, this is all cosmetic damage, and we pointed out to the court, but the problem is there's no cosmetic damage exclusion. And so the court struck all of their experts, okay? And that's the way it ought to be. But, think about it like this. If, when your car gets dinged up because of hail, okay, well, that's covered, all right? That's because there's no cosmetic damage exclusion in an auto policy. And so it's the same as with regard to, property damage, real property damage. And so if there's not a cosmetic damage exclusion, it's covered. It does not matter if it's cosmetic or not. This is what you typically see. We do not pay for any cosmetic damage to the roof structure of any building or structure to which this endorsement applies for wind, hail, rain, snow, sleet, or ice. One of the things I get all the time, or I get people call us up and they send some photos and they say, well, this was denied because they said it was cosmetic only. What do you think? You want to take the case? And, the biggest question that you have there is what's the policy say? Because there are lots of different insurance policies with different cosmetic damage exclusions, and some of them are impossible to get around and others are very easy. We have not lost one yet. And I think really that's because we don't take cases that we think are really cosmetic, okay? And I'm gonna show you how to evaluate that. So this is typically what you have to look in the policy and see what the definition of cosmetic is. And typically what you're looking for is something like this, that it means that the loss is caused blemishing dents or other superficial damage that change the appearance of the roof structure, but does not include the failure of the roof structure to serve as a barrier against the entrance of elements to the same degree as the roof structure did before the cosmetic damage occurred. So think about that. From a legal standpoint, that doesn't mean that you have to blow a hole in the roof, okay? If you've got hail or wind or any other thing that caused damage to the roof, and that metal roof or other type of roof is not going to last as long as it typically would. Let's say it's a 50-year roof and you've taken 10 years off because of dents that are later going to rust. That's not cosmetic by definition, okay? And so what you have, well, let me go through it and I'll show you what the insurance companies do and how to defeat it. First, I want to show you some of the cases that we've had that were denied for cosmetic reasons that ultimately we ended up winning. This one was Colorado Springs in 2016. You can see all the dents there. This one was in Roswell, New Mexico in 2017. By the way, if you haven't been there, the alien exhibit is uneventful, okay? It looks like little tin hats and stuff, but anyway, it was interesting. Amarillo, Texas, this was what looks to be an aluminum shingle roof in 2018. And so here's typically what you get from the insurance adjuster. I reviewed the field adjuster's report concerning your claim. He inspected with your property manager, and they found, like your property manager found, that it was cosmetic, right? But they found that the hail impacts are cosmetic in nature only. And then it's, so sorry, you have a cosmetic exclusion. We're not going to pay the claim. Now, well, let me back up here. Let's see. Well, here's the problem that you have with most of these. The insurance companies want to save money, and so they don't send anybody out there to actually do an analysis whether or not it's cosmetic. It literally is somebody, even sometimes not even getting on the roof, maybe looking at photos or even listening to what the inspecting adjuster has to say, and then they deny it. I mean, they literally just eyeball it and deny it, and you cannot do that. Is everybody familiar with Jim Kuntz? Kuntz White and Associates, I think they are now. We've had a bunch of cases with those guys. Well, Kuntz will now opine that damage to a roof is cosmetic without even going to the property. And I'll show you what happened in the case that and he did that in New Mexico. So in Colorado, we got a really good report one time. It's the only engineering report I've ever seen practicing law where they actually said that it was functional damage. And it was out from Knott's Laboratories. And they really gave you a good roadmap that you can use to try to determine whether or not it's cosmetic or functional damage. And the first thing they said was if the hail damage to the metal panel roofing, or that it occurs when indentations resulting from the hail impacts are such that the roof can no longer effectively shed water from the surface. Okay, so here's how we have interpreted that. It's to mean that if you have dents in the roof that are deep enough to where after it rains, even the smallest raindrops are still left in that little indentation, what's going to happen is it's going to evaporate, and then you're going to have sediment, and that sediment is going to lead to rust at some point in time. I don't know if it's 2 years, I don't know if it's 5 years, I don't know if it's 20 years, but I know this, the roof no longer functions like it did before to shed the elements, okay? So that's one way that it is functional damaged. And here's a good picture. You can see there that you had a dent, and then water was in that hole, evaporated, and then you've got sediment. That sediment's going to lead to this right here, hail dent with rust from water ponding. Okay, you see it all the time. In fact, we've actually gone back on some of the cases we've handled, and 3 years after the fact, to go see. If they didn't get the work done, whether or not it actually rusted. And sure enough, these things do rust after a few years, okay? The second thing that we got now remember again, this is the insurance company's report. And they say if hail damage can result when the impacts have resulted in stress fractures and have compromised the integrity of the roofing material, which results in premature deterioration of the metal panel and a reduction in the service life, okay? So here's a picture of that. And, the thing that's important here, and I'll even step back and say it's really important in every type of claim, but photos, guys and ladies, really, you've got to get good photos. I can't tell you how many times people refer cases to us, and they've got, a nice overview of the roof from a drone, and they've got photos from 30 feet away, and I look at it and I say, did you take these photos? Well, yeah. I mean, because it looks like the adjuster took the photos to me. They try to take photos from 40 feet away and from everywhere where there's not damage, okay? And what we tell our experts when we're preparing for trial is, I want the closest photo you can possibly get, like this. This photo, I don't know how far, it's probably 6 inches away, but that's a stress fracture. And what is the insurance company going to say other than, it's a footfall or some crap that they'll make up, okay? So photos, it's really important, especially in these types of cases. The third thing that Knott's Lab said was that hail damage to metal roofing results when hail deforms the roof panels at the seams or at fastening locations. Such deformations can result in rupturing of the metal or disengagement of the lapped element that affect the water shedding capabilities of the roof as well as the expected service life of the material. So here's a picture of that. Now, if you really do have functional damage from hail, for example, you're gonna find this stuff all over the place, okay? It's really simple. And then if you can combine that with roof leaks, and you've got an insured who says, this didn't start leaking until last Thursday when the hail came, okay? You've got a really good case there. But photos like that from that far away are what you're looking for. The fourth thing Knott's Lab said was that damage to surface coating can result in premature corrosion of the metal or long-term deterioration of the surface coating resulting from retained water within indentations. So here we're going to see some stone-coated steel, and anytime you can see metal, that's functional damage, okay? Here's another one, that's functional damage. I don't care what they say to you, and I'm gonna tell you, when they argue with you and they say, well, you know, that's just the coating, it really doesn't do anything. Well, what do you think the coating's for? Okay, you think it's for, you know, cosmetic? I bet not. Look, here, I pulled this off the internet, and so when you're having to deal with these insurance companies, you know, pull this up and say, look, this is the Girard stone-coated steel, and there's what, 2, 4, 6, 8 different coatings. Okay? They all serve a purpose, or they wouldn't be on there, all right? Here's the DECRA pamphlet that I got off the internet. Again, you've got what, 2, 4, 6, 8 different coatings. And it tells you, by the way, what each coating does. It's really difficult for an insurance adjuster to deny a claim when you've got damage to any of these coatings because they tell you they're functional. They all have a function, and when it's damaged, that is no longer cosmetic. This is the reason why we win these cases, by the way. These experts make these just fatal mistakes, and fortunately our courts are really good at excluding these experts who do this, okay? And so here's the first one. And I see this a lot. They don't do any scientific testing whatsoever before arriving at the conclusion that it's cosmetic. So, you know, there are standards in all courts that experts must go by, and you can't just say, yep, that's cosmetic for sure. I mean, how can you do that? Nobody's got the ability to eyeball a roof and talk about whether it's cosmetic, but the insurance companies do that all the time. Why? They don't want to pay for the testing, okay? That's why. The second thing they do is they use a different definition of cosmetic than is what actually in the policy. And that's fatal, and I'm going to show you here in a second why. So this is some deposition testimony, and I don't remember who I was taking the deposition of, but he says that there is no hail damage that would affect the life or weather tightness of a metal panel roof. And I said, now what this guy had done, I said, well, I want to know what's the test that you did to determine that it was cosmetic? And he said, well, I spit on it and then I wiped it off. And if there wasn't any corrosion underneath, that's cosmetic. Jesus Christ. I said, well, yeah, that's what I said. I said, well, do you mind, sir, if I call that the spit and wipe test? Because when I get that in front of a jury, they're going to laugh just like you did and say, Jesus Christ. Okay. So he said, well, sure, that sounds like a good test right there. So now, other than the photos and the spit and wipe test, you didn't do anything else. And he says, yeah, that's correct. I said, you didn't do any testing to determine whether or not from a microscopic level there's any damage or penetration of the dirt that's shown in picture 6, remaining in picture 5, correct? And he says, well, I got it zoomed up as far as I could, and that's as close as I could get to it. That's how he determined that it was cosmetic, all right? Well, here's what the court said. Talkikin provides no basis for the court to evaluate the methodology with which he determines whether a roof has suffered functional or cosmetic damage. Moreover, Talkington provides no indication that he applied any reliable principles and the methods to the facts of this case. Accordingly, Talkington should be excluded from testifying as an expert. And that's what happened, and then they settled it because the spit and wipe test, turns out, doesn't pass federal court muster. All right? Here's another one you see all the time. This one happened to be, everybody know Gary Boyd? All right, Gary Boyd's an expert that insurance companies like to use. I'll tell you a couple of different things before I go through this about Gary Boyd. Boyd is one of these guys who, he's a jack of all trades, okay? He says, well, I'm an estimating expert, and one time I asked him, because he came up with some, he was a building consultant at the time, is what he said he was. And I said, so I want to be real clear, you don't actually do any of these jobs. That's correct. So this job that you said that could be done for $50,000, this is something you could do. Yeah, that's right. And you've actually got the staff where you could go out and get this job. That's right. And it would be profitable. He said, oh yeah, absolutely. Of course, my expert said it's going to be 3 times that. So I slid him a contract and said, well, you got the job, sign there. And I mean, I think. And he started accusing me of all kinds of things, and but he didn't like it. But, you know, that's what these building consultants, you know, they're there to provide lowball estimates, but then nobody has to do the job for that price. Anyway, so this time he opined that this is cosmetic damage, all right? And I said, do you have an appreciation that sometimes the cosmetic damage might vary from policy to policy, you know? And he says, yeah, oh yeah, I know that. And I said, well, the definition that you will be testifying to is the one stated here according to USSC. I don't even remember what USSC is. Does anybody know what it's not the United States Supreme Court, I know that. Okay, it was some funky standard he found on the internet or something, and he said, okay, yeah, that's right. So here's what the court said about that. The court agrees, Safeco has failed to meet its burden to show that Boyd's testimony is relevant because it's based on a definition of cosmetic damage that differs from the insurance policy's definition. He relies, and then he says, for the reasons here, the court grants Collins' motion to strike Boyd's designation an expert, okay? And so they do this all the time. They try to take some Hague engineering definition or some definition from something other than the policy, and all of that is irrelevant. Your policy is going to define what cosmetic damage is, and that's the only definition that they can use. If they don't, it's not relevant and they can't testify. When they can't testify, that's a big deal. I'll show you why. So you struck the expert, okay? So here's a little insurance law 101. It is the insured's burden to show that the dents in the metal were caused by a covered cause of loss, usually hail, okay? It doesn't really matter what the cause of loss is. It's the insured's burden to show that there is a loss and it's covered. You don't have to show the extent. You don't have to show how much it's going to cost, just that there's a covered loss. So I got hail dents, a hailstorm occurred, here's video, here's the weather report. It's all on you now, okay? That's your burden as an insured. Then the insurance company's burden is, and they usually admit that, by the way. So you've met your burden. Now the burden shifts to the insurance company. If they want to deny the claim, they have to show that it's simply cosmetic and that there's a cosmetic exclusion, okay? The problem with it is they can show that there's a cosmetic exclusion because the policy is going to be in evidence, okay? But when their expert gets struck, they now have no way to say that this is cosmetic because you can't put just some insurance adjuster or just some regular individual up there. It actually requires expert testimony, as we showed you in the federal court. So you've got to meet certain scientific principle standards, okay? So you can't just have somebody say it. When they have an expert that gets struck, they no longer have anybody to say that. They can't meet their burden, okay? They can't meet it, so you win, period. So they won't even take it to trial, all right? All right, so that means this. The Colorado Springs case, that was an estimate of $575,000, and we settled it for $1.525. And the reason for that is because they know they're going to get hit with bad faith. And with bad faith comes attorney's fees and a whole slew of other problems that they have to deal with. So that's what that settled for. The Roswell, New Mexico one, this was a really good story. So this is one of the greatest judges. It was Judge Gonzalez, I think it was. And we had a motion to strike their expert because he did all these things that I just told you about, where they don't follow the policy language and they eyeball it. This was the one with Jim Coons, by the way. And Coons didn't even go up there. So he opined in the federal report that it was cosmetic damage. He'd never even been to the property. And not only that, he used the wrong definition. So we file a motion to strike, and the judge says, all right, here's what we're gonna do. We're gonna have a hearing, and here's gonna start at 10:30, and I'm gonna let you argue for an hour. After that, I'm sending you to our magistrate, and you guys are gonna mediate this case for an hour and a half. And if you don't settle, I'm gonna rule. And I promise you, one of you is not gonna like it. And of course, I'm feeling great, because I'm like, well, I know what the law is. The lawyer on the other side's a moron, okay? They haven't done this. So in the middle of the mediation, the magistrate comes over and says, what do you think the judge is gonna do? I said, look, respectfully, you might think maybe I'm cocky or whatever, but we know what we're doing. That judge is striking them. I've seen her opinions. I've read every opinion she's ever written on striking experts, and she's gonna strike them, and I know it. And those guys are writing us a check, and it's gonna have a 2 in it, and if it doesn't, we're going to trial. In 30 minutes, they gave us $2 million, okay? And those are really nice because, you know, this was for a church, and of course the pastor told me that it was God did it. You know, well, that's great. Well, God got you more money than you even need to do the roof, so. And then this one here, you know, just a little residential claim. $75,000 roof, sold it for $150, okay? That's what happens. And so if you can bring all of this evidence together, even before you've got any attorney involved, but you know, when you're dealing with the insurance companies as a PA or even a contractor, obviously, you know, you've got some rules you got to follow there. But, you know, if you can provide them the photos and, you know, all the information I'm showing you here, you can get these things settled because they'll see that they're shot, okay? All right. So what do you do when the insurance company actually does meet their burden? When they actually go and they do microscopic testing and they actually have a legitimate, if there are any insurance company engineers, but anyway, a legitimate engineer who says that this really is cosmetic, then you've got to find somebody to say opposite, but that doesn't mean go find somebody to lie about it. Some cases really are cosmetic, okay? And just know that, and don't try to push a case. If you can't find any of those 4 things that I just said that show that it's functional damage, then it's probably cosmetic, and let it go. Because that's what the exclusion's for. It's not to be used in every single instance, but sometimes you've got little tiny dings or blemishes and it's cosmetic, and let it go, okay? When we do, I just want to put a shout out to Todd Stern. Todd, I think, is speaking, I think it's later today or tomorrow, I can't remember which, but Todd has done some engineering work for us on these cosmetic damage exclusion cases, and he does a really thorough job. If you've got one of these issues, there's his website, and just go to it. You can contact him there, but he's really good and helped us win a bunch of these cases. Okay, let's move on to the Prompt Payment of Claims Act. And this is only in Texas, by the way, but people don't understand what the Prompt Payment of Claims Act actually does, okay? So let me back up and explain to you one thing. The number one question that we get from clients is, how in the world am I going to get all my damage fixed when you're going to get a percentage of it? And I explain it to him, and I explain it to him what I'm about to explain to you, and I swear to you, it is the most sophisticated ones who just never get it. I mean, it's the guys with PhDs, and it's other engineers, you know, that are clients. I mean, they just don't get it. But it's pretty simple, okay? Twofold. Number one, in the state of Texas, when you file a suit for a breach of contract and you win, the other side has to pay your attorney's fees. It's not the reverse, by the way. If they win, you don't have to pay theirs. Only goes one way. An insurance policy is nothing but a contract. And when you win that, they've got to pay your attorney's fees. So we don't ever negotiate any settlements without considering attorney's fees into it, okay? So we tell our clients, if it's a legitimate claim and they didn't have some, you know, prior claim that they got paid for and never did the work, okay? But I'm talking about a legitimate claim, and they want to settle it. We say, do not settle this for less than your full damages plus your attorney's fees. Because the insurance companies have a lot of downside. And I'm going to show you some more of the downside in a second, but they also have the treble damages from bad faith that they're going to be facing if you have to go to trial. So that's the first answer. The second one is the Prompt Payment of Claims Act, okay? And it requires an insurance company to pay interest and attorney's fees if they fail to meet a single deadline under the Prompt Payment Act. Okay, go back, just read it. All you have to do is look up Texas statutes, and you'll come to a website there and go to chapter 542 and just read through it, okay? They almost never meet the deadline. I mean, almost never, all right? Well, here's what the problem is for them, and people just don't know this. Well, first of all, let me tell you what some of the deadlines are. They've got 15 to 30 days, depends on what type of insurance company they are, to acknowledge receipt of the claim and start investigation. They usually meet that, although I will say in hurricanes and large natural disasters, they don't, because they don't have enough adjusters. They don't want to hire enough, okay? So they blow that one sometimes, but usually meet it. The one they really don't meet is that they got 15 more days to accept or reject the claim. They almost never meet that. If you look in Louisiana right now, I don't think they've met this anywhere. Now the Prompt Payment Act is different, but they've got, because it doesn't apply in Louisiana, but they've got some similar statutes, okay? But they never accept or reject within 15 days. And then if they accept it, they've got 5 business days to pay the claim. Well, we all know they don't do that. It doesn't even matter if they agree, okay? If they blow any of these deadlines, and there's some other ones in the Prompt Payment Act as well, here's what you get, okay? If it's a weather claim, 21.5% interest per annum. Now, that's when you combine the Prompt Payment Act with prejudgment interest, okay? But think about this. We've got Hurricane Harvey claims. We're probably down to 5 or 6 of the bigger ones right now that the insurance companies just fought and fought and fought, and we've had to go up to the Court of Appeals and back. I've got one in particular for a retirement home in Houston, and it's about an $8 million claim. We're coming up on 6 years. So they've got to pay 21.5% per year. I can't even do the math on that. What's that, almost 130% interest. And attorney's fees on top of that, okay? A non-weather related claim, so fire claims, 26.25. Now, the reason it's this, by the way, is because all of this is based on prime. Both prejudgment interest and prompt payment interest is based on prime rate. And as you've all noticed, the prime rate's gone through the roof. So this is what they're facing right now. And, you know, I'll say another thing. When you don't have to have an attorney to get this, by the way, they owe it. We just got an opinion from the Fifth Circuit a week and a half ago. We got I mean, you don't see this happen on the Fifth Circuit, okay, but we got a class action certified against Geico. Because Geico, remember when Hurricane Harvey came and there were 500,000 cars that flooded, okay? Geico decided they were gonna pay the value of the car, but not tax, title, or license. And we got that class certified, and the Fifth Circuit just upheld it a week and a half ago. And part of what they upheld was, well, first the certification, and second, they said the Prompt Payment of Claims Act is a strict liability statute. And what that means is they don't have to have intended to violate any of these deadlines. The deadlines are the deadlines. If they blew it, they owe it. Okay, so when you're looking to negotiate these claims as a PA, you know, take this into account, because that's going to get your client made more than whole after your fee. All right? People forget that. So it's a really big deal now that the prime rate has gone through the roof. We're starting to handle a bunch of cases in Louisiana, and if, you know, anytime there's a natural disaster, you've got lots of public adjusters that go in, and they do a good job, mostly. But public adjusting in Louisiana is different. Everything in Louisiana is different, I think we know, okay? But, you know, you had a big storm there, so a lot of people were there trying to help these people out. Public adjusting in Louisiana is different because there are several requirements that the fee has to meet. Number one, it's got to be reasonable, and that depends, it's on a case-by-case basis, okay? Number two, a public adjuster shall not enter into any contract which provides for payment of a fee to the public adjuster which is contingent upon or calculated as a percentage of the amount of any claim. In other words, you can't just say, I get 10%, okay? What you can do, and any such contract, by the way, is null and void. Now, this is a direct quote out of the Louisiana revised statutes, all right? Your contract under Louisiana law can be on an hourly basis or can be on a flat fee. And that means one of two things. Your contract has to either say we're charging you $3.50 an hour, whatever it is, or we're charging you $50,000 period to do this, okay? Whatever the number is. But it can't be contingent, all right? Or it's void and illegal. Chip Merlin wrote in his blog, and this is September 21, so remember, this is a month after the hurricane hit in Louisiana. I know that some are simply not going to accept this and will try to come up with some scheme to work around laws regarding getting paid on a contingent basis. I suggest that public adjusters read the Louisiana Attorney General opinion, and the opinion says basically what I just told you, okay? So Chip saw this coming. Here's what happened to us recently. We settled an IDA case for $700,000, and I sent an email to the public adjuster who was involved and said, I need you to send me an invoice. And he sent an invoice for $70,000. Well, that just happens to be exactly 10% of what the case settled for. So I sent back to him and said, look, you need to understand in Louisiana law, you can't just charge a percentage. I'm happy to pay you for your time, or if you had a flat fee, but I need your contract, okay? Or in your timesheets. Well, here's what his contract said. It said that the insured agrees to pay the adjuster a flat, he called it a flat fee, okay, but calling it a flat fee doesn't make it a flat fee. All right, he said in exchange for performance of services outlined in section 2, the fee is determined based on the adjuster's total valuation of damage. Okay, and then the insured agrees to pay the adjusters no more than 10% of the adjuster's total estimated cost for damages. That's a contingent fee, folks, okay? It's based on somebody's evaluation of the damage. It's not a flat fee and it's not hourly. So there was he was blasting all kinds of stuff over the internet, and we responded to him, well, you know, the Louisiana Attorney General has specifically stated that this contingent-based schedule would be repugnant to the Louisiana statute, which says it's void against public policy. So basically, your PA agreement is void under Louisiana law because it's based on a contingent interest. Understand, we're not trying to not pay people here, okay? We're trying to do things legally and ethically. If you're not watching in Louisiana and Florida, then go get a bucket of popcorn and get on the internet and spend about 2 hours, okay? Because it's interesting and it's gonna show you exactly what not to do. I continue that if Louisiana were a state that allowed PAs to retain contingent fees, we'd happily have honored that. We do it in other states where it's permissible, and we'll be happy to do so with you in the future in permissible states, but we don't violate statutes and ethical rules via backdoor deals. Those are the kinds of things that MMA has been doing, and it will cost them all their licenses. We just don't do those kinds of things, period. I concluded, we're more than happy to pay you for your time working on the case, and we'll do so out of our fee, but we're going to need detailed timesheets in order to do so legally and ethically. And I know this isn't what you want to hear, but this is the career and licenses of people at Daly and Black at stake, and we're not going to risk them for anyone or anything. What I got back was, well, now my fee's $92,000. Okay. As of yesterday, the Louisiana Department of Insurance called us and wants every communication that we have with this guy about this. So now he gets to answer to them, all right? Here's the bottom line, it's just not worth it, folks. Just comply with the law, okay? There aren't enough people in the entire country to fight the insurance companies on the bad things they do. There's plenty of good cases out there because they're greedy, all right? You don't need to violate the law to go get what you're entitled to.